co-counsel appear before the apex court of Diana today. Your Lordships, may I please the court. I and my co-counsel appear before the apex court of Diana today, representing the petitioners, Mr. Prominent, the NGO Jan Swasth Seva, and the Federation of Tobacco Companies in the club petitions filed before this court. The counsel for the petitioners will be arguing on 5 issues. For the first 21 minutes, I will be addressing the issues of the maintainability of the writ petition, the constitutionality of the regulations imposed on tobacco products, and lastly, the unreasonable classification made between tobacco products and e-cigarettes in the impugned legislation. For the next 21 minutes, my co-counsel will be addressing the 2 issues of damages that Mr. Prominent is entitled to from the state and from the Federation of Tobacco Companies, and the unconstitutionality of the special exclusion clause in the insurance contract under Article 14 in the Constitution of Diana. We respectfully reserve 3 minutes for rebuttal. Would your honors be inclined to would your lordships be inclined to hear a summary of the facts of the case, or may I proceed with the subject?
No, you proceed. Please proceed. Don't go to the facts.
Thank you, Lordship. It is recognized that the most fundamental challenge before this court today would be to balance the right to trade of the Federation of Tobacco Companies with the right to life of Mr. Prominent. And I earnestly hope that after hearing our arguments, the court will rule in favor of the petition. Proceeding with my first issue, it is submitted that the petition filed by the 3 petitioners is maintainable. Firstly, Mr. Prominent's petition should be considered maintainable under Article 32, as it is a writ petition filed for violation of his fundamental rights, and the mere existence of alternative remedies is not a bar to the admissibility of a petition, as per the case of Ramesh Thapar versus the state of Madras. In the case of Union of India versus Paul Manikam, it was held that reasons for not approaching the relevant High Court must be shown by the petitioner before approaching the Supreme Court directly. And it is submitted here that given the nationwide scope of this petition, the life-threatening medical condition of Mr. Prominent, and the urgent need for obtaining relief, the requirements of the same are met. Further, in the case of Guruvar Devaswam Managing Committee versus C.K. Rajan, the Supreme Court held that even if an individual files a writ petition in his own personal interest and for the redressal of his personal grievances, a holistic outlook could still be adopted by the court to provide remedies for public interest in the very same petition. It is further humbly submitted that the PIL filed by Jan Swasth Seva is admissible as it is filed in a bona fide manner for the enforcement of fundamental rights of a large number of people and is in accordance with the PIL guidelines laid down by this court in the case of Guruvar Devaswam Managing Committee versus C.K. Rajan. Further, it is humbly submitted that the Federation of Tobacco Companies, while being a juristic entity, while being a corporate entity, can still file a petition for violation of fundamental rights if the rights of its constituent natural citizens are adversely affected, as per the landmark judgments of Bennett Poland versus the Union of India and Sakal Newspapers versus the Union of India. Moving on to my second issue, the council would like to clarify that this claim would be argued in accordance with the clarification number 19 that has been issued.